Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a very important webinar on the tariffs. The subject is Tariffs Stressing You Out, 3 Steps to Stay Ahead. So our incredible attorney, Alex Barthet, will be going into the 3 steps that are absolutely imperative to ensure that your contracts are rock solid. If you do have any questions, we're here to answer them. On your screen on the right-hand side, you'll see there's a webinar chat box. Feel free to ask any questions in that box. So let's get started with our agenda. Tariffs, what are they? Reviewing your contracts, provide prompt written notice, amend your pending and future contracts, and then we'll answer any questions. So let's get into the 101s of tariffs and why it is so important to have this webinar. So tariffs are taxes that are on imported goods. They're used to protect domestic industries, and they generate government revenue. And of course, they respond to foreign trade practices. Who pays for these tariffs? U.S. importers, not foreign companies, pay the tariffs. Tariffs are generally collected at the port of entry by the U.S. Customs. So, for example, if a U.S. contractor buys imported steel, the importer pays the tariff and passes the costs down to the supply chain. So, who feels this? Obviously, suppliers and distributors, because they're going to pay more to bring in the tariffed goods. Contractors and subcontractors, they're going to get hit with higher material costs. Project owners end up paying more due to the increased bids or change orders. And ultimately, the customer or taxpayer, whether it's a private or public project, the end user absorbs the costs. So I don't have a screen on this, but I want to give everyone a very quick timeline of tariffs and construction materials so that we have a little bit of a history of this so we can understand. And then most importantly at SunRay, and of course the Lien Zone and Alex Barthet, we're here to protect you in every way, shape, and form. But understanding the history and what tariffs are all about is imperative to protecting your company. So a quick timeline, pre-2018, tariffs were common, but generally low and not heavily targeted at construction materials. Most construction imports flowed freely under the global trade agreements like NAFTA and WTO rules. In 2018, there were major shifts that began. U.S. imposed in Section 232 tariffs. So there was a 25% on steel and 10% on aluminum global. And then Section 301 tariffs on Chinese goods, including construction materials. Then from 2019 and 2023, tariffs expanded and adjusted. They continued disputes over Canadian softwood lumber. Tariffs ranged from 8% to 20%. And now in 2025, tariffs reinstated and expanded, now impacting steel, aluminum, copper, and some electrical and mechanical components. So while tariff existed before 2018, they weren't a major disruptor for construction until the trade wars began in 2018. So without further ado, Alex Barthet will give a small introduction and he will explain what you need to do to protect your company, and primarily with these price escalations. And that's why we are on this webinar, to help protect you. So Alex, please, let's get into the real meat and potatoes of how to protect our clients and our customers.
Thank you, Ariella. My name is Alex Barthet. I'm a board certified construction attorney here in Florida. And we're going to talk about ways to protect yourself with the existing contracts you have and future contracts you may enter into as to the current tariff issues. So let's get started. One of the best resources that I have found to at least keep an eye on what's happening, because they are constantly in flux, is a website called TradeComplianceResourceHub.com. And if you click on the link called the Trump 2.0 Tariff Tracker, they have a running list that is updated daily of all of the various tariffs as applied to each country, and within each country, the goods applicable that are being assessed the tariff. So if you're curious about what the current status of a tariff is in a specific country, go to TradeComplianceResourceHub.com and look for the Trump 2.0 Tariff Tracker, and it'll tell you. So let's talk about step one of the 3 steps that I think you need to focus on in order to deal with the current state of affairs with tariffs. So first is you need to review your existing contracts. If you believe that tariffs are going to impact your ability to provide materials on a project, you need to look at contracts you have already executed. Now, if people are signing your contract, you probably are much better off than if you are being forced to sign other people's contracts. If you have to sign someone else's contract, it may say things that are good for them and bad for you. So some of the things that you may want to look for in that contract are words to the effect of some ability to make a claim for material price escalation, references to tariffs, taxes, or duties, changes in the law, or force majeure or circumstances outside of your control. Now, these are various provisions or language in your various sections of your contract. I can't tell you what they may say. It may say that you're not entitled to any material price escalation, that you'll absorb all tariffs and taxes irrespective of changes in the law. So it may be things that are good for them and bad for you, but people sometimes think, well, if I look for tariffs and it's not there, then it doesn't exist in my contract. And the reality is that there are lots of other places that these provisions may exist that you should look for. So for example, we had a client who had a contract that was relatively silent about material price escalation, but did give him an ability to make a claim for cost increases related to changes in law. So we argued successfully that this tariff change is a change in the law from the time he signed the contract, and we are currently negotiating an equitable adjustment based on that provision. So again, the concept here is don't just look for tariffs, look for some other components in the contract that may give you rights to make a claim. So what happens if your contract is silent on the issue, meaning it doesn't say one thing or another with respect to tariffs or making a claim? Then my advice is that you should use that as an opening in order to make a claim, right? So if it doesn't expressly prohibit you from doing it, then you should go ahead and make the claim. So let's talk about step number 2, which is what does that claim look like? And it's very important that you provide prompt written notice of any claim you wish to assert. So if your contract has a notice provision in it, that notice provision is probably very short in time, meaning it's not uncommon for us to see notice windows in the 48-hour or 72-hour range, right? Which is obviously exceptionally short. But maybe you have 3 business days or 7 days, or the most I've seen is 21 days. Irrespective of whether what the time frame is, and quite frankly, even if you pass the time, it is important to submit notice. If you wish to make a claim, having or providing notice versus not providing any notice is absolutely critical. If you end up in court and you never made a claim, you never submitted notice, the other side is going to say, how were we supposed to know? They never told us. Versus you're while it's not great, it's better to say, yes, I recognize that the notice provision was 72 hours and it took me 10 days to give the notice, but at least I provided the notice. And when in front of a judge, the judge has the ability to say, well, I think that 10 days is fine, even though the contract said 72 hours. No one was prejudiced. So you know what, we're gonna say that notice was good. So again, making note or providing notice is better than not providing notice. So here is a sample generic notice that you should modify as appropriate to your circumstances. So you'll put this on your letterhead and you will send it out via whatever requirements your contract has. Some say certified mail, some say email. So here's the letter. The subject line is going to be notice of claim of U.S. national emergency and imposition of tariffs, request for equitable adjustment, and you're going to list the project name and address. So what's interesting about this, the manner in which these tariffs have been imposed, and quite frankly is the most interesting legal hook that we can hang our hat on here, is the fact that the president has declared a U.S. national emergency. And that, interestingly, may create rights that wouldn't exist otherwise. So the letter starts, on April 2nd, 2025, the President of the United States formally declared a national emergency. As part of the declaration, the United States has recently applied new significant tariffs as well as increased existing tariffs on the import of raw materials and finished goods. This national emergency and recent changes in law constitute a force majeure event and will have a substantial impact on the cost and possibly time associated with our ability to provision materials and goods under our contract with you for this project. The exact scope of the cost and schedule impacts are not currently known, as the applicability of various tariffs is currently in flux. The next paragraph reads, the potential delays and increased costs are without any fault or responsibility on our part. Unfortunately, we cannot absorb the costs in their entirety. Notwithstanding, know that we are committed to mitigating the impacts on this project. And then the last paragraph is, please consider this letter our notice of claim and request for an equitable adjustment. It continues to be our goal to minimize costs and maintain the project schedule. Further information will be provided in subsequent correspondence once we have analyzed and calculated the impact of the tariffs on the availability of materials and goods on the project. Feel free to contact us with any questions, and then you'll go ahead and sign it. Again, this is a very generic notice. It's more to put a stake in the ground and let someone know that something may be coming. Now, obviously, to the extent you have more specific information applicable to your situation, you should use that instead. So again, rather, if you've actually suffered a loss or an impact, you should provide that notice. Again, whether you wish to tailor this notice with that other information or provide your own notice. But no matter what, I think your notice should include, to the extent you have suffered an impact because of the tariff, it should include the specific materials that have been affected by the tariffs, right? So whether it's steel, electrical wiring, aluminum, the projected estimated cost and schedule impact, and the method of calculating those items, right? So don't just say, you know, aluminum's been impacted, we need another $50,000. You need to provide all of the detail on where the aluminum is, where it came from, where it's coming from now, how much the tariff is, what's the time frame for getting it if there's a schedule impact. Next, you should, to the extent possible, cite the relevant contract clauses that support your right to make a claim. We talked about that earlier. Is there some provision in your contract about force majeure or changes in law? To the extent you have a specific provision you can cite, that's what you should do. If not, you'll effectively leave it empty, which may make it more difficult to support your claim, but it shouldn't eliminate your thought in order that you should submit a claim, so maybe you can get something. Next, provide the supporting backup of the schedule or material price increases such as notice from your vendors, charts and graphs and tables from trade organizations that track the commodity. The website I mentioned earlier, which has the information about the current state of tariffs, bills of lading or import duties that have been imposed upon you already. Again, the more information you can provide that this is not a speculative request, but a specific request because things are actually, you are actually spending money to solve this problem. What is also important, because it's typically the question you get back, is you need to provide whatever support you have of your attempt to lock in a price during an early portion of the project, right? So people don't want to pay you to deal with this tariff issue if they perceive that you haven't done anything to protect yourself, right? So if you haven't done anything to lock in the price, it's going to be harder to get someone to give you extra money in the form of a claim. But to the extent you have purchase orders or contracts with other people where they were supposed to absorb the cost, or you did what you could to lock in the price as best as possible, providing that support to show the person you're asking for extra money, hey, look, it's not like I just ignored this and it snuck up on me. Look at the things that I've tried to do early on, purchase orders very early in the project to try to lock in the price, but they're getting hit, and therefore that means I need to pass it on to you. So we talked about what to do with your existing agreements. We talked about the notice provisions and a sample notice letter. Let's talk about what to do for your existing contracts. Your future contracts that you have yet to execute. We are proposing that our clients provide or insert a tariff-related provision. So here is a sample. Again, you should modify this to the circumstances that apply to you, but it reads, notwithstanding anything herein or the contract documents to the contrary, contractor / subcontractor, again, it depends on who you are in this scheme of things, shall not be responsible for delays or costs related to declared U.S. national, state, or municipal emergencies, changes in law, duties or tariffs, and any supply chain issues resulting therefrom, collectively, in quotes, an emergency. And again, contractor or subcontractor, depending on who you are, shall be entitled to an equitable adjustment in the contract price and schedule as a result of the foregoing, provided, however, that, again, contractor or subcontractor shall not be entitled to any markup for profit / fee on the portion of the cost increase. So we're seeing our clients able to get some version of a provision like this included in their contracts. Again, the intent is that it is rather broad to cover things that are happening now and potentially things that may happen in the future. One of the changes that we're seeing people make is they want to add in another sentence suggesting that to the extent that the tariffs subside, that there would be a credit given back to the extent that that tariff doesn't apply anymore. And that's fair, right? So the idea is if you have to suffer a loss because of a tariff increase, if that tariff changes and now the number goes down or goes away, you shouldn't be entitled to keep that extra money. And most people are fine with that. Most people that we run into are just looking to have this tariff cost, specifically the cost alone, get covered by someone else up the chain. So let me end with a pro tip, okay? And that is, you need to also consider adding an exception to your monthly in progress releases for the outstanding claims, including your tariff claim. Let me explain what this means. So you submit this notice of a claim of a potential tariff that may be imposed upon you. Now you get to the end of the month and you have to sign a release to get paid for that month. Well, depending on how that release is written, you may be asked to release any claim, known or unknown, in the past when you sign that release to get paid. Well, guess what? That would potentially include the notice that you gave on potential future tariffs. So you want to exclude from your release claims and notices that you've given previously. By the way, you should also be doing this for pending change orders, so that they are excluded from your release. But the language to do something like this exclusion, would be to add the following to your release. Notwithstanding anything herein to the contrary, nothing in this waiver or release shall waive or release the undersigned's rights in and to, and then this is where you're going to add whatever it is you're trying to exclude from the release. So for example, tariff-related claims based on written notice dated April 15th, 2025. And then you'll end with all of which are reserved, right? So this sentence allows you to exclude from the release that you signed in order to get paid any claims related to this. And you'll need to include this every month in your release just to make sure that you are not releasing your rights to be paid for this claim, because that's the other problem is even if you may have a legal right to make the claim, if you sign a release that gives away that right, then you no longer have that right to assert at the end of the job. So with that, I would suggest that if you have questions about your contract, you can use our free contractdetective.com tool. You can upload a contract up to 100 pages and it will send it back to you highlighted with various provisions noted. You can click on those links and it will take you to a little video explaining each of those provisions and what you can do about them. Again, completely free. You can go to contractdetective.com. And with that, Ariella, do we have any questions?
No, we do not have any questions, and I'm sure the people that are listening to this webinar are going to ask where they can get those forms, and not to worry, we will be sending everything out to all of the viewers, so you will have all the forms and language. And as always, Alex, great webinar. Thank you so much. And I wish, and oh, of course, if you do have questions, here's our contact information. We're here to answer anything, any questions you may have. So I wish everyone a sunny day and thank you so much.